When you leave behind a legacy, you're not just transferring money, you're transferring clarity, values, and peace of mind. But every heir is different, and what works for one beneficiary may cause conflict, confusion, or even tax trouble for another. Understanding the key differences in your beneficiaries is essential to building an estate plan that respects your wishes and serves your family well. In today's episode, we'll break down 5 of the most common distinctions you need to account for and show you smart, strategic ways to plan for each one. All right, Spencer, we're going to start off today and we're going to talk about beneficiary designations and how to really think about these strategically. Because again, as we've said in the past, we love all of our heirs equally, so we treat them differently. And sometimes we really need to think about this in a tax efficient manner. So let's first talk about beneficiaries that are in different tax stages or in different states.
Well, we've got a number of different pieces here. Usually, as we work with clients, they have beneficiaries who are not going to be identical in terms of their tax situations. So they're not all, say, at a marginal 22% tax rate, planning to take out resources at the same points of time. Instead, there are a number of different pieces. So one is the state that the beneficiary lives in. Great state of Tennessee, we do not have state income tax. So that gives our beneficiaries oftentimes an advantage over some places that might be like California or others that would have a state income tax that would be higher and would need to be something that we need to potentially factor into our decision making as we think about what assets to position where. So again, the state is one key. Another key is the federal marginal tax rate that a beneficiary might have. So if we have, for instance, one beneficiary who has a job that pays $50,000 on an annual basis, has been diligent in that work, but their marginal tax rate is only 12%, versus another beneficiary that perhaps has is an executive with a company, makes over $1 million on an annual basis, has a marginal tax rate of 37%. That's a very, very big difference there. So you could just kind of bury your head in the sand and say, I've got, 4 different accounts. Everybody's going to get the same amount from every account. I've got non-qualified, I've got Roth, I've got pre-tax resources, and we'll let them decide. We're not going to have any kind of conversation about how to optimize this. And, Uncle Sam may take and put his greedy paws in your pocket and take a little bit more. And that might be fine. But just be aware that taking more can be actually significantly more. Sometimes it can be, even north of 10 or 15% more of an estate just via tax than would have needed to be taken otherwise if you had, some planning there. So want to be careful on that. Again, we've got state taxes, we've got federal marginal taxes, and then we've even got distribution rates there. So think about this. Think we've got a pre-tax set of resources, a Roth set of resources, and a non-qualified set of resources. And we've got 3 beneficiaries. If we've got one beneficiary that wants to use the resources upfront immediately upon receipt, and that, maybe that non-qualified set of resources is going to be one place that we would start with that beneficiary, because there's a step up in cost basis there. There's not going to be tax due on that sum of resources. Let's just say we have another beneficiary who's very, very charitably minded, who wants to, in essence, try to give away all of those resources. And let's just say we have that beneficiary is also in their 70s. Well, now that beneficiary could do a significant amount of charitable giving via qualified charitable distributions on a beneficiary IRA. So if they receive pre-tax resources, it's not going to harm them if they're just pushing them on to charitable institutions. Let's say we have another beneficiary who says, I don't know what I'm going to do with these resources, but I have a high level of income right now. So I'd prefer to take as little as I can and may have high income down the road as well. Well, the Roth side might be really, really helpful for that beneficiary. So, we think about those 3, and the distribution path on those might be all very different, where we have one wanting to use up front, we have one wanting to use over time and giving charitably, and we have another that wants to defer everything just as long as possible, but also has a high tax bill if they take anything out from a pre-tax standpoint. So we think about that distribution sequence, and that can also be, a really key one there as well. The other thing to bear in mind is we've got 10 years from qualified assets to be able to take those out. And so if we have clients who have beneficiaries that might be in their mid-40s, why they may be in their working years throughout the entire time of their inheritance. We may have another beneficiary who may be 60 and may be nearing retirement there. So that beneficiary, if you can pass more pre-tax resources on, may have better tax planning there because, again, their income's going to drop, their marginal tax rate's going to drop, they may have more space to take out resources. So again, think state, think marginal tax rate on a federal level. Also think about the timing, for the distributions when we're factoring in all of these different pieces with tax brackets.
Right. And I think, Spencer, the most critical piece of this is a communication piece. If you decide to do this unilaterally and say, well, I know that this kid's going to do this, I know this kid's going to do this, and I know that one's going to do that, and you just write it into your beneficiary designations, and then one of them receives the non-qualified, one of them receives the pre-tax, and one of them receives the Roth, and they look at it and they're like, I see that it's equal, but why did mom and dad do this?
Right.
It might cause consternation. So really just have upfront conversations and say, hey, listen, I know that this person is going to need to buy a house or they want to buy a house, and we want to bless them with that. You, if we gave this to you, 40% of it's going to the federal government. And then this one over here, he works as a teacher, and the Roth resources are going to be better for him. Just have the conversation. It might go pretty well because then your kids are going to understand, your heirs are going to understand, oh, this is why mom and dad did it. This actually makes a whole lot of sense rather than just saying unilaterally, this is what Spencer and Austin said to do. I'm going to do it and I'm not going to tell anybody. That may not go as well.
Well, or just saying I'm going to divide evenly and everybody gets a even pro rata share. They may say, okay, well, we understand that's fair is fair. But they may also look at it and say, gosh, there's a lot going to tax here that doesn't necessarily have to, given the fact that we have different needs, different perspectives, and different distribution sequences.
Right, absolutely. All right, so let's talk about the second key differentiator to really think about here. And this is the idea of a spendthrift beneficiary versus one that's maybe a little bit more financially disciplined. Talk us through how to think about those two different beneficiaries.
Well, the question comes back to how much do you want to speak beyond the grave? And this is a fraught situation. There's no right or wrong answer necessarily, but you have to get comfortable with whatever path you choose here. On one side, if you have a beneficiary who has not made good financial decisions and money actually may harm that individual, then you have to grapple with what you're more comfortable with. Are you more comfortable with setting some parameters, creating some friction potentially with those parameters, but sometimes really helping that person and keeping them from doing something that would be really negative, really harming them? Because I can't tell you the number of times that we've seen beneficiaries receive resources and there were already small fires going on in their lives, and this just pours kerosene onto that small fire, and it kind of blows up. So receiving resources can be a tremendous blessing, but it can also harm people. And so we've got, as we have these conversations, we try to help clients grapple with what path they're going to be more comfortable with and how they're going to actually bless their beneficiary more.
Absolutely.
Could be either way. And putting parameters in place, like a trust or some kind of restriction in terms of how a beneficiary can use resources or the pace that they can make withdrawals, it can create friction. So again, having that conversation up front, making sure that the beneficiary understands why this is being done and that there is still a tremendous amount of love for that beneficiary is really critical. Now, on the other side of things, if you have beneficiaries and they're being treated differently, that can also create friction. Because if you have two beneficiaries and both of them receive assets in trust and both of them have some protections in terms of how quickly those resources can be pulled out, then sometimes the beneficiaries will just go along with it and say, well, mom wanted to be able to protect, both me and my sibling, in a comparable way. If you have differences there, which can absolutely make sense, then you also need to be aware that it can create friction between siblings. We've seen that happen a number of different times. So whatever path you choose, just recognize that a decision has to be made. And there's not a perfect decision. There's going to be friction that's going to be created, or there's going to be people that are going to potentially be put at greater risk, and you have to grapple with what path you're most comfortable with. You can set up a trust, and you can put a trustee in place that can have some capacity to slow down those distributions or make sure that they're being used in a way that is more consistent with your core values. But there are trade-offs there.
Absolutely. So Spencer, the next one we're going to talk about is married versus single, but also blended family issues. What are some of the complexities here that we need to consider?
Well, married versus single, if you have a beneficiary who is married and also has children, then you need to be thinking through, okay, if that beneficiary passes away, do I want those resources definitely to be passed down their line to their children, to be passed to their spouse? What's the thought process there? If you have beneficiaries who are single, it's more straightforward. But if you have one set of beneficiaries that might be married, another set that might be single, then you want to make sure that you consider what's going to happen if you have, heaven forbid, a beneficiary predecease you or pass away, in a common accident. There, typically clients will set up a designation that would be known as per stirpes, or they would write put together a trust where assets again would go down through their line, where the children would be the beneficiaries and potentially a trustee or a guardian would be put in place there. But we have seen estate plans where the surviving spouse is the recipient. There's a high level of trust potentially between the decedent and surviving spouse of the son or daughter there. So that can also be a good solution. But you just want to think through that particular one. Now, that is a small issue compared to really thinking through the complexities sometimes that arise with blended families. The key here is going to be making sure that you communicate what your intention is. Because if you have children from another marriage, let's just say, and each spouse has children there that they bring to a new union, and then we have one spouse pass away, then typically there's going to be some kind of friction because there may not be alignment with the surviving spouse and then the children there. So you need to have thought through this and say, okay, this is exactly how we're lining this out. Most folks, they're going to have a significant priority on making sure that surviving spouse has enough during his or her lifetime. But they also want to probably grapple with the fact that they want some resources, if that concern is taken care of, then to be passed down to their children. So oftentimes a QTIP, a qualified terminal interest property trust, will be helpful here. Right. So what that does is basically you put assets in there. The gain on those or the interest on those can be distributed to surviving spouse during his or her lifetime to be able to take care of his or her needs. But the remaining amount there then goes to the named heirs, oftentimes who would be the children of the first spouse that passed away. So there are ways that you can set up an estate plan that helps to grapple with, how do we make sure that we have enough for surviving spouse, but also pass resources on to other heirs that are priorities in that person's life.
Right, absolutely. Next, we want to discuss minor versus adult beneficiaries. And we have done a more deep dive on this one, as well as the one thereafter, about beneficiaries who have special needs. So can you just talk us through at a high level, what are the considerations for minors versus adults?
Oftentimes we'll have a situation where we look at the will, and in usual circumstances, the resources will pass directly to son, daughter, that first line of beneficiaries. And let's just say this first line of beneficiaries, they're mainly in their 40s. But let's say, heaven forbid, that one of those beneficiaries has passed away, and now there would be assets going to a second line of beneficiaries that would be under 10. Oftentimes, within the context of that will, there will be that testamentary trust that says, if this happens, now this set of resources goes into a trust that's going to have a trustee named here, and the beneficiaries of that trust will be that second line of people that would be the grandchildren or even great-grandchildren there. Because what you want to make sure that you do is you name the person that you're most comfortable making those financial decisions. You don't just pass along resources to an 8-year-old and say, well, let's just make sure that the courts in Tennessee will name a guardian or a conservator in this situation. It's going to be a lot of time, a lot of money, a lot of heartache and headache for everyone involved with that. So better for you to go ahead and make those decisions up front, have the appropriate structures in place where those assets move to the care of a trustee who's going to look after that minor.
Absolutely. Okay, let's talk about this last one. Again, we dove into this one before, but beneficiaries with special needs versus independent beneficiaries.
Mm-hmm. So in this one, we've got to make sure that we understand the characteristics of the special needs beneficiaries and how they receive income and any kind of governmental assistance that they're getting. If they're getting governmental assistance, then if they make too much money, if they are given distributions for certain types of unqualified or disqualifying needs, then they can lose access to certain government benefits.
Yeah.
So they can be actually put in a much worse situation than they would have been if before that $10,000 distribution, that might have come. So we want to make sure that if there is a special needs beneficiary, that those resources will be pushed oftentimes to a trust with a trustee that has latitude to be able to help them in ways that do not disenfranchise them from those benefits that they would receive otherwise. So there's a whole level of complexity. If you want to see a long trust document, those special needs, supplemental needs trusts are some of the most complex ones. There are different types of those. There's a third party and a first party. Typically the third party trust where resources come in from a grandparent or a parent and they are never owned by the beneficiary, but they are held by that trustee to help the beneficiary, are going to be those that do not disqualify the beneficiary. And so there has to be a significant level of care that is thought through in that kind of estate plan. So if you have a loved one, a beneficiary who's going to be receiving assets, you need to make sure in your estate plan, you need to make sure that you've considered that and you've got the appropriate language.
Great. Well, Spencer, thanks for walking us through the intricacies of each of those different types of beneficiaries. The reality is sometimes these are all going to blend together in some way, shape, or form, that maybe some are minors, some are adults, some have special needs, some are independent, some maybe are better or worse with money. The reality is walking through and navigating all of this can be incredibly complex. So clients, if you want to talk to us about how you think through your beneficiary designations, where you should have accounts located and which beneficiary should be named the heir of that account, we would love to have that conversation with you. If you are not a client, please talk with your financial advisor about this. Talk with your estate planning attorney. And until next time, take care. If you like these financial planning videos, please share with a friend. And if you have questions, go to our website at SeriousRetirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at SeriousRetirement.com. The information in this recording is intended for general educational and informational purposes only and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.